Good afternoon. I'm Benno Kimmelman, and on behalf of NYIAC, the New York International Arbitration Center, it is a pleasure to welcome you here this afternoon. First, I'd like to express our deep thanks to Debevoise and Plimpton for hosting us for this event this afternoon. And it's really so good to see so many of you here in person. It's something we all pray for every time we schedule an event, and it's really wonderful to have you here. To introduce the program, let me call to the podium Anna Jubin-Brett and Martina Polasek, who will tell you about this afternoon's program.
Thank you very much, and a very warm welcome to all for joining us here. Many thanks to Debevoise, and thanks also to NYIAC. It's a tradition every time UNCITRAL is in town to have one of these meetings of the Grand Central Forum. So I'm very, very glad to see all of you here. So for us, it's an auspicious meeting because it takes place during the UNCITRAL Commission session, the commission where we are adopting the texts that are being worked on by our working groups. And it's also a very good opportunity to talk about one of the next products that will come for the Commission's adoption next year, which is the Code of Conduct. One of the first elements of reform of ISDS for us, and sort of a late addition to the amendment process at ICSID. So I just wanted to say that, and you to know, but I'm sure you do, that this is a joint endeavor between the two secretariats of UNCITRAL and ICSID. We are preparing the documents together. We prepared the drafts together, and we are continuing to take to service the meetings quasi together. And we're currently working on finalizing the commentary to the code, which if you know how we work in UNCITRAL, there's a lot that is not put in the text, but is let's put it into commentary, or this will find its place in the explanatory note. And that's how it happens, that the commentary becomes then very bulky. And it's also a work in and by itself to have a balanced commentary. So that is where we stand. I'll give the floor to my friend and colleague Martina to say a few words on behalf of ICSID. But we definitely look forward to hearing from this extraordinary panel, and also from all of you, the comments on where we stand. It's going to be a very important step forward, and we very much look forward to this interaction with you. Thank you.
Thank you very much. I'm very pleased to be here on behalf of ICSID, and very pleased to continue this collaboration with UNCITRAL about the Code of Conduct. It has been very productive so far. We've come up with 3 drafts and a lot of in-between communications about various drafts. I would say that Article 4 of the code, dealing with double heading, is probably the most important provision in the code. And so I'm happy that we have this panel to talk about it also outside of the context of Working Group 3. I think that's very important to hear the feedback from the arbitration community in general. So thank you very much. I very much look forward to hearing the views here today from the audience and from the panel, of course, and to continue our work on this. Thank you.
I'm going to start by, first of all, thanking NYIAC for doing this. I mean, having a forum to discuss important issues, and this is indeed an important, compelling current issue, is an important part of its mission. And so you'll all be happy to know that we are assisting NYIAC in performing its mission by having this discussion tonight. And I also want to add my thanks to Debevoise for its generosity in hosting. And I want to do that now, although I'll probably do it at the end as well, because Deborah Enix Ross and Will Taft, who are the current representatives of Debevoise to the NYIAC Council, are in the room. So thank you on behalf of all of us to them on behalf of the firm. So as you'll all know, there's a fourth draft of the ICSID UNCITRAL Code of Conduct for Adjudicators and Investor-State Disputes now under consideration by UNCITRAL Working Group 3. The code has appeared on the agenda of this week's council session here in New York and will be discussed again by the working group at its session in the fall in Vienna. As I've said, NYIAC has convened this forum tonight to discuss a specific issue addressed by that code. That issue is what is frequently called double hatting, though I keep saying, though I haven't come up with a new one, that there must be a better term for it. I'm going to try to use multiple roles. Working Group 3 has defined the practice as individuals switching roles as arbitrator, counsel, and expert in different investor-state dispute settlement proceedings. Many of us who practice international arbitration, but also serve as arbitrators, have wrestled with this issue for some time, and various individuals, various law firms for whom it typically arises or more frequently arises, have come to different views about how one works through that. To my mind, and we'll get into this much more deeply, the issue that arises is whether and to what extent those multiple roles compromise the essential requirement of an adjudicator's impartiality and independence. And so we might think of the code of conduct provisions addressing the issue as trying to come up with a practical consensus about how those fundamental principles should be applied in this specific context of investor-state arbitration and the prospect of multiple roles. One clarification before we start, well, one point about methodology. The panelists and I have talked, and the organizers have talked quite a bit, and you'll be very happy to know that we are not doing talking heads. You're not going to hear successfully for people's views. We're going to try very hard to have short and succinct presentations, comments by others on the panel, and then hopefully time for comments from folks in the audience. We recognize there's a great deal of expertise and experience on the floor as well as up here. And then the point of clarification. We are not going to debate tonight whether the practice of engaging in multiple roles should be excluded across the board. We recognize that there are not an insignificant number of states, other commentators, other participants that take that view. And of course, if proposals to create a permanent investment court with full-time professional judges were to be adopted, that court would moot the issue discussed here tonight to the extent of its jurisdiction. But that policy issue is beyond the pay grade of this panel up here and this particular, it's not our focus. We're going to proceed tonight on the expectation that even if a proposal of that kind were to be established, a court of that kind, which is far from certain, it will be sometime in coming. And in any event, it may not fully displace the system of ad hoc arbitration that we now use. So we're going to address the specific issue, as I say, of multiple roles on the expectation that this will be a live issue for some time. We're going to be led in a discussion by a truly distinguished group of panelists. They've agreed that we're going to do very short introductions. Professor Andrea Bjorklund is the Fortier Chair in International Arbitration and International Commercial Law at McGill in Montreal. She was, amongst many other things, ICSID's inaugural scholar in residence. Mandell, to my right, is Special Counsel at Wilmer Hale's Washington office. He served in multiple roles at the U.S. Trade Rep, including as the lead U.S. negotiator for the investment chapter of the U.S.-Mexico-Canada agreement. Kate Brown de Vejar is, to my left, is the global co-chair of arbitration and the deputy managing partner of DLA Piper's Mexico City office. She represented Australia at the meetings of UNCITRAL Working Group 2 and the Commission from 2008 to 2017. And Andrés Jana, to my left, if I may say so, is one of a small handful of leading arbitration figures in Latin America. And as soon as I say that, I really do not give him full credit because he's one of the small handful of leading arbitration figures in the world. I meant to clarify this, but Jana and Hale is new, no? Okay, so even in our working papers, he was still at Bofield-Mir, but he is no longer. He has now established a new firm in which he's a partner. Andrés has acted as a Chilean delegate before UNCITRAL, as a member of the ICSID panel of arbitrators, and serves on the governing board of ICA. So here's the opening proposition. I said it a moment ago. What should drive the provisions in the Code of Conduct are the fundamental requirements of impartiality and independence. And what the code should aim for, and what we're going to try to explore tonight, is consensus on the application of those fundamental requirements in the concrete context of investor-state arbitration. Andrea, do I have it right?
Yes.
Please.
Okay. Well, so I get to lead off. Thank you for that kind introduction. It's really a pleasure to be here and a pleasure to be back with you for the first time. Thank you for. So Donald asked me to consider whether the limit on multiple really addresses concerns about independence and impartiality. We look at, to see that, we look from Article 4 to Article 3, where we have a short discussion of independence and impartiality, with, I think, a little more focus on the idea of independence and perhaps a little less on impartiality. So generally speaking, independence has to do with relationships with parties, whereas impartiality has to do with predisposition or bias. Now, of course, there's a link between these. You might be more likely to be partial if you are not independent, and presumably vice versa. One of the things that I think the successive drafts illustrate is that these are very hard areas to explore. And indeed, you see discussions about whether these should be gauged on a subjective basis or on an objective basis. But of course, subjectively, it's difficult because only the person who might or might not be impartial in particular knows whether he or she is or is not impartial. Assuming that we can find some kind of Platonic ideal of what it means to be truly impartial. So I think what that means is that in the rules, we tend to try to find proxies for assumptions that people might reasonably make. And we see this most in terms of what has already been established for many years in many contexts, are rules about nationality. The presumption of loyalty, that if you are a national of one state, that you are presumptively loyal to that state. So we see bars, sometimes subject to party autonomy, but bars to serve on a tribunal if you share a certain nationality with one of the parties. Now, as we all know, some people have multiple nationalities. It's complex where perhaps one's loyalty lies. Some people might have a disaffection with their state of nationality. But those are areas, again, that are hard to explore. So we let the nationality bias serve as a proxy. And I think in the Article 4 now, the current version of Article 4, you see some of the same attempts to use proxies for assumptions. And the benefit of that is that it addresses, at the very least, the appearance of bias. And in some other instances, it might actually address actual bias. Now, what does it mean to be impartial? Usually we think that means to come to the case with an open mind, yet presumably, and this is one of the complexities, you presumably are coming with an open mind, but against a backdrop of expertise and experience. It would be the rare counsel who appoints an arbitrator who says, I've never heard of regulatory expropriation. I have no idea what that is. I have no ideas about that whatsoever. I know nothing about that. I think you would probably feel that you were not abiding by your ethical obligations if you indeed found somebody and appointed somebody who truly had no ideas in advance about that issue. But bracketing that for the moment, if one acts as and this is the kind of the core double hatting issue, the
concurrent activity as counsel and as arbitrator, and especially acute when one has the same or very similar issues. And one, let's say, an award in one case, I always find it fascinating the link to transparency, right? That an award in one case might affect the outcome or the arguments in another. But if you act as counsel primarily for claimants and you also sit as an arbitrator, the likelihood that you have a predisposition in favor of claimants might be higher. And certainly the appearance that you might appear to be biased is higher. That might not be true, but it might be true. And given the concerns about the legitimacy of investment arbitration, I think it's fairly easy to discern why that particular kind of role. And the same was true for respondents. I'm not picking on claimants. The same would be true the other way, but why that has certainly been addressed. But it tackles one particular appearance of bias problem that seems especially salient to the public. The code purports plans to prohibit multiple roles in other guises as well. So no expert work and arbitrator work, no expert work and arbitrator work. That makes things, I think, a little bit more, when I say a little bit more complex, but the thing that isn't addressed, and this is this conundrum of what is in people's minds, is you can certainly just decide to sit as an arbitrator and sit as arbitrator in multiple cases. If you've been an arbitrator for 10 cases and you've had 10 claims of regulatory expropriation, are you really free of any kind of predisposition about what a regulatory expropriation claim should entail? Yet that activity is not prohibited. You're acting as an arbitrator. You have, if you will, assumed the mantle of judge, and you can continue to engage in that activity. I think that seems reasonable, but I do just put that out there for consideration, that if we're really concerned about your mindset and whether you have some predisposition about a certain legal issue, and that's one of the rather broad categories that we're considering, then if you've already sat as arbitrator in multiple cases, presumably you have some predispositions about that issue. So it seems that the ban is about something more than just predisposition, but about appearances of bias. And I'll stop there.
Yes, thank you, Donald, and thank you, Andrea. With respect to this question of the relationship between independence and impartiality and the code, I'd make an observation on the architecture of the code. And for those close watchers of the code, you'll see that there is an article in the code entitled Independence and Impartiality, Article 3, that is not the code that explicitly disciplines double hatting. That would be Article 4. And I think architecturally that raises an interesting question as to why. I think clearly, I would not at all disagree with Donald's observation that concerns about independence and impartiality are absolutely front and center, as Andrea also articulated, are front and center in the consideration of how should we frame a double hatting restriction, if at all. And yet you have a separate article there. And I think the answer to that question, from my perspective as an observer in the working group, is that the attempt in Article 4, rightly or wrongly, is to identify per se categories where we eschew the analysis of, is this circumstance, does it result in a lack of independence or impartiality? We fiat that in these circumstances, the practice of double hatting multiple roles would be banned. But it does raise the question of, is this the exhaustive list or not? Article 4, does it provide the exhaustive list of scenarios that do result or could result in an excludable, a bannable practice of double hatting? And I think that right now the code is silent on that question, but I think that the answer should be addressed in the commentary to the document, and that there should be an acknowledgement, perhaps in the commentary to Article 3, that again, for greater certainty, as a former US negotiator would say, for greater certainty, Article 4 addresses per se instances of bannable, excludable double hatting. But there may be facts and circumstances not addressed in Article 4 that could result, based on the facts and circumstances of the case, in a lack of independence and impartiality. And I'll stop there. I think there's a lot that could be done in the commentary on this question. I would say that less is more. A kind of a narrow and clear observation like that would be sufficient, but that will be discussed, I'm sure, in the working group as well.
And the proposal of having a floor, but not excluding other circumstances might be one that should be explored. Just a very quick comment. That's why the way I think of the attempt here is somewhat like what I think is a huge contribution of the IBA rules on conflicts a long time ago, where everybody had these assumptions, but it was useful to try to define, I don't think anybody's talking about red list and orange list and all here, but it was extremely useful to identify what was consensus about what was absolutely a conflict, what we shouldn't bother about, and what might require greater consideration. Kate, your thoughts?
Thank you. I wanted to check how many people have a copy of the text in front of them. And if you don't have one, please do know that there's some in the room, because what we're going to be engaging in. So I don't mind if people jump up if you want to, if someone wants to come and grab some, because I actually think
we wanted to make this easy, so grab a hard copy.
And I actually think it's really helpful and informative for the discussion so that you can see the structure of the provisions that we're talking about.
And it's very short.
And it's very short. So what we're looking at, if you have a draft of it in front of you, is the draft code, particularly Articles 3 and 4. And you'll see that Article 4 is the one titled Limit on Multiple Roles. Okay, so we've all got a copy. I feel like a professor who's about to start asking questions of the class and finding out who didn't do their homework. So you see exactly what we've been talking about, that the actual provision on limit on multiple rows is Article 4, but then there's the rules about independence and impartiality in Article 3, and there's an interaction between them. And you look at what that interaction is, and exactly as Lauren said, you've got here in 4.1, if you look at it, certain things that are said to be problematic. And what we're saying is, unless the disputing parties agree otherwise, an arbitrator shall not act concurrently, and there's some language in parenthesis, as a legal representative or an expert witness in another IID proceeding, and some language in parenthesis. And then there's certain conditions there, which we've said these are problematic, involving the same measures, the same or related party, and some brackets, and the same provisions of the treaty. So exactly as Andrea said, like nationality, these have been identified as criteria that there's a consensus forming, if it haven't formed already, that these are problematic per se. With the exception, at least in the current draft, that if the disputing parties decide that this is not problematic, they can agree otherwise. And I think that's an interesting issue, because if the community at large has decided that this is problematic, is it okay that the disputing parties agree otherwise? And I think that's something that we want to talk about, because to my mind, part of answering Donald's initial question, is this all driven by independence and impartiality, is who is the audience we are addressing with this? If it is just the disputing parties, then that carve out makes complete sense. If we are dealing with the perception of the broader community at large that this is an issue, the public, other parties who participate in international arbitration but may not be parties to a particular proceeding, and they have determined that they think this is problematic, and that it goes to the heart of the legitimacy of ad hoc adjudicators of these kinds of disputes, is it right that we are allowing the disputing parties to agree otherwise? And obviously there we're getting to the interaction with party autonomy, and I know we're going to address that in a little bit while, but I think when we think about, is this driven by the concepts of impartiality and independence, it's also about who are we reassuring that the arbitrators of these proceedings are independent and impartial. Thank you.
Thanks for that. I mean, one of the things that makes this, of course, a more problematic or perhaps more complicated than in the commercial case is that we're assuming that states, that there is a public interest in investor state to a greater extent that there would be in the standard commercial case, which drives much of this. Lauren, can you take us a little bit deeper into some of these by commenting on how a limit on multiple roles would work in practice? I mean, what roles should be excluded? How do we determine when a proceeding ends? Let's get more concrete now that we've identified, or I think we have consensus about what the norms are that should drive this, but let's get more concrete about how they apply.
Thank you. Happy to. At the outset, taking your premise that we're not really discussing the pros and cons of a total ban. We're talking about what I call a tailored ban, a limited ban, a modified ban. Many terms have been used in the working group. It would not be difficult, I think, as a drafting issue to ban double heading totally, whether concurrently or with a 3-year, 5-year, 10-year, God knows, tail permanently. But that's not where the working group's primary work is right now, in my observation, in part because I think numerous delegations have raised concerns with a quote unquote total ban with respect to party autonomy, with respect to its effect on the arbitral pool, on the pipeline for new arbitrators, et cetera. And so the current draft, the major thrust of it is trying to negotiate this tailored ban. And I want to observe that I think the logic of a tailored ban is as follows. I'm not sure that this has been expressed in the working group, but I think it informs the work of the working group. And that is that we're trying to identify double heading scenarios that raise the greatest concerns of a conflict of interest, and then creating a kind of per se ban, again, without prejudice to what Article 3 might do in a kind of a facts and circumstances world. And if that is right, I would add, I think that the logic of this approach is to achieve consensus. Anna and others can speak to the challenge of achieving consensus on nearly anything when you have the United Nations in front of you. But the idea is to establish a minimum consensus standard that the states can agree. These are the scenarios that raise the greatest likelihood of conflicts of interest. And not to say that states can't, in their own treaty practice, take a more aggressive approach, even a total ban, as you see in some recent agreements. Now, the question that you've posed is, how can a tailored ban, a limited ban, work in practice? And here I'll make another observation. I think for a tailored ban to be administrable, a prospective arbitrator at the time of the constitution of the tribunal should be able to decide with a reasonable degree of certainty whether taking the appointment would be consistent with or run afoul of the ban. Because that really is the moment when the rubber meets the road on any kind of double hatting restriction. And specifically, if you don't have that kind of clarity for an arbitrator, and Donald and Andrés and Kate and Andrea, I think I'm the only person here who has not served as an arbitrator, perhaps. I'm not sure. I think a prudent arbitrator with a lack of that kind of reasonable certainty, reasonable clarity, will naturally decline an appointment because they cannot be certain or even have sort of a minimal degree of certainty. Will something that arises in this case result in a conflict that requires me to disqualify myself or subjects me to a reasonable challenge? And so if that is right, and it may not be right, I welcome alternative views. I think by this standard, Article 4 still needs some work, not just in the commentary, but in the code itself, in the drafting of Article 4. And here I'll highlight as an example, Article 4.2, which you have the text in front of you, I won't read it, you'll have it in front of you, but it covers circumstances where you have a concurrent practice, arbitrator, counsel, or arbitrator expert, or some variant, and there's a relationship between two cases in terms of the legal issues, substantially so similar legal issues that result in a lack of independence and impartiality under Article 3. Now, again, the question is this administrable as a test? Is it a functional, tailored, narrow ban? And I think the answer is no at this point. And I'll assume for the sake of argument, I have strong views on this question, but that this drafting itself is sort of creates a coherent test. And we can talk about that. But let's put that as a question aside. Let's assume that through further drafting and great minds that we'll be able to make this test one that is clearly, concisely understandable by parties, by witnesses, by everyone involved in the process. But I think that the question is, how can a prospective arbitrator, again, at the time of constitution of the tribunal, determine the range of legal issues that might appear in the case? And I think the answer is they can't. They won't know the treaty claims. They won't know the defenses. They won't know, even if, kind of an ironic circumstance, they won't even know if they'll be called upon to interpret this code. And does that also create a same legal issue or similar legal issue restriction? And they won't have information really in either case, right? That if they're counsel in a concurrent case, they may not know at the outset of that case or even far along what kinds of legal issues may arise. And so I think that makes this a non-administrable provision. I know that I'm running short on time. I do think that when you look at other provisions of Article 4, Article 4.1a, same parties, same measures, you do not have that same administrability question necessarily. With respect to same treaty, same legal provision in the same treaty, you have that issue, but perhaps more manageable than with respect to 4.2. Before I conclude, just to highlight or to address the other question that you posed, Donald, and returning to the beginning on when you're drafting the mechanics of a double hatting ban, whether it's a total ban or a tailored ban, considering some interesting technical questions like when does the proceeding end? When does the proceeding end for determining, can I now take on this representation or not? And I have to say, I thought this was an easy question. And then I sat down and started to draft and I realized, oh no, it's not. And the way that I have articulated this, I'll state briefly. I think literally with respect to each of the provisions of Article 4, you could apply a different approach. And so when you look at 4.1a, same measure, 4.1b, same parties, I think there's a strong argument that the proceeding should arguably end when A, the time period to request annulment or set aside of the award has elapsed without a request for set aside or annulment, or B, if the annulment or set aside has been requested at the conclusion of those proceedings. Until then, following the logic of the code, there is an argument that there is a potential conflict of interest in multiple roles. But then you look at 4.1c, the same treaty provision, and you look at 4.2, similar legal issues. And here I think arguably the proceeding should end earlier for the purpose of the ban. And that's because whether or not the annulment or set aside involves that same legal issue or involves the same treaty provision is uncertain. And you could imagine a complicated conditional test on if the annulment or set aside involves the same legal issue, then the double hatting ban and the conclusion of the proceedings goes on until the end of the annulment process. I fear that that may be difficult to administer in practice. Now, the other issue, the harder issue perhaps, is on enforcement of what about enforcement proceedings? And honestly, I think this is when you have to cut bait in the sense that if you have a double hatting ban that the duration of which looks to enforcement proceedings, well, God knows where an award is going to be enforced, if it will be challenged, what are the rules in terms of timeliness for that enforcement action and the challenge to the enforcement. I fear that if you start considering the duration of an enforcement action or enforcement actions, you end up with effectively a permanent ban. Pause there.
Although the question might be determined as to, is there a prospect that it would come back to that arbitrator? But Kate, do you agree?
I do not, or at least I'm going to add a level of complexity because I agree with your last comment. I think what you're talking about is where there's a scenario where that arbitrator may be called upon to continue to act in the role in some way. So they may be continuing to look at the issues. And I think that actually brings me to what I think is the core issue. I don't think it's so much the duration of the proceeding. I think it's the duration of the role. What if the arbitrator resigns? What if the arbitrator is successfully challenged? What if there's a settlement or there are different things that can bring around the end of the arbitrator's role? And is it necessarily the case that it's the end of the proceeding that is really what we're interested in? If the arbitrator themselves stops acting in that role at a particular time, is that not the relevant time to be considering? And then secondly, in terms of when the proceeding ends, I tend to agree that where you might want to be looking is if there's any chance of remit for any purpose, then I think you would be in a scenario where you could arguably say that that arbitrator will be continuing to act in that role. If there's no possibility of that, is that the relevant point that we should be talking about? So I do think that there's that as a practical consideration. So I think determining when something ends, so when a proceeding concludes, is certainly one of the practical issues. And I also completely agree that where I certainly agree with you, Lauren, is the interaction between 3 and 4 and how that works as a practical matter is interesting. And I do invite everyone to look at 4.2 and see that what we're talking about here is an arbitrator acting concurrently as a legal representative or an expert in another IID proceeding involving legal issues. So we're clearly in the realm here of some predisposition with respect to an issue. And when you become aware of that is certainly important, which are substantially so similar that accepting such role would be in breach of Article 3. So at this time, you're dealing with that at the point of accepting the role. It's the scope of what you are aware of at that point in time. And then you look at Article 3, and you're looking for accepting such a role would be in breach of Article 3. And if you look at Article 3, it says they shall be independent and impartial, and then you've got the square bracket language. So there's an interaction here in terms of timing, because there's at the time of acceptance of appointment or confirmation shall remain so until the conclusion of the IID proceeding. So if we have that and shall remain so through the conclusion, which I think that goes to the heart of what we're really worried about, right? Because we're worried about the fact that there will be issues in those cases that will overlap in some way that we think is unacceptable. So then you have to be looking at it throughout the duration of the cases, but that gives rise to the timing questions that Lauren pointed out. But also, what do you then do? Does this provision give rise to a duty to resign if the conflict arises later? Does it simply give rise to a duty to disclose and the parties can choose whether you should continue in the role or not? And if you look at the subparagraph 2 within Article 3, there's some articulation of what's included in this obligation. And I went through those and I tried to find the one that works with the issue conflict. And the only one that I could find that really works with the issue conflict is probably G. Take any action that creates the appearance of a lack of independence or impartiality. So obviously I've got a duty under subparagraph 1 to be independent and impartial, but if I think I am being, but I'm worried about an appearance, what would be the acts that I would take that would cause a third party, an independent third party, to think I am being impartial? And how does that interact with the issue conflict? So I think there's a little bit of thought perhaps to be given in terms of practical guidance.
There's also a tension between you might suggest that the solution is that you just not take on the representation, or that you withdraw from the representation because you have to privilege the commitment you made. But that seems a bit awkward. Certainly you don't want arbitrators looking around for potential conflicts and then resigning in the midst of the proceeding. But Andrés, you'll have the perfect solution to this conundrum. What is it?
No, I don't, but I don't think it's that complicated as well. In a way. Let me take first 4.1. I don't think 4.1 first it creates a lot of problems. First, in 4.1, paragraph 1 speaks about the same measure, then the same or related party, and then the same provision. So first, let me start by the same or related party. Well, that's nothing new there, right? If you are a lawyer and also you're an arbitrator, adverse to the other party, you cannot do it. And under the IBA, that would not be possible. Even the IBA have 3 years of time, so that's nothing new. You don't need a provision like this to know that you cannot act as arbitrator or lawyer where the same party is involved. So in that sense, I don't think that is created any limitation that is already doesn't exist. Same measure, it says the same measure. I I would understand that by the same measure, it's only a measure that can be adopted by one country, right? Not by different countries. So already the respondent will be the same. So I don't think you need the same measure if you have the same party. So the two are only one exclusion, not two exclusions, because it's or. So right, if the respondent will be always the same, maybe not the claimant. So really, what you have is something that is not new at all, and then you have the same provision of the treaty, which is much less what that you will see in the CPTPP or CETA. So I think 4.1 is reasonable, and I will explain later that it's reasonable, as far from reasonable, because it's trying to strike a balance in the different views of the working group. So that's the difficulty. That's what maybe 4.1 is not perfect, and also is then 4.2. I think 4.2 it's a bit more problematic because 4.2 is uncertain. What I like about 4.1 is an objective test. You don't have to do any assessment. It's certain. You know, as an arbitrator, that if the same provision and you're acting as counsel, you cannot accept, and you cannot accept being counsel if already you're arbitrator, and it's the same provision of the treaty. I insist, the other one for me is captured already by any standard of impartiality and independence out there. The problem that I see in 4.2 is that may create uncertainty or will create uncertainty because in addition to everything that has been said, it will not be clear to determine when exactly is the same legal issue or substantially the same legal issue. And also is this issue that you may understand that the legal issue is very similar, well advanced in the case as often happen. Some of the version of the states proposed spoke about facts or measures, not legal issues. Actually, legal issues have been contended for the reasons that we are discussing here. At the end, it's not the same fact, which is objective somehow, or measure is legal issues. And to finish then, so my concern that would be if it's not more reasonable, instead of creating an appearance of a ban, because at the end you are sending this to Article 3 anyway, to leave this to the commentary and let Article 3 to deal with the issues of impartiality and independence and leaving it at 4.1. The commentary will be an official commentary, so it will have force. And it seems to me that in that way, if you leave to Article 3, you will probably allow the decision, the jurisprudence, the cases to evolve and establish a reasonable or a proper test, and not create something that could be said an appearance of a prohibition, but at the end is really, you know, it's creating a test which is uncertain for independence and impartiality.
Okay, we've asked you to take the lead on bracketed text about the 3-year exclusion.
So I think that the short answer is that including something like the 3-year tail probably gets closer to addressing the concerns that were raised that gave rise to addressing the double hatting issue to begin with. That there was that the concerns were not limited to concurrent acting, that there were things that you could do that, you know, you'd just been counsel in a case where you argued very strongly in favor of or against a particular position, and can you really then, within a very short period of time, turn around and form a completely different independent view on that same issue, potentially under that same treaty, in a decision-making role, in an adjudicatory role? And so I think the 3-year is an attempt to address that extended version of the concern. I think the worry with that is it's just it's much harder to enforce. If you go beyond a concurrent assessment, I think to Andrés' point, concurrent is easy. Concurrent is, are you doing it at the same time? In which case, that's a no. if you start talking about 3-year tails or until past the end of the proceeding, then you do start, I think, the discussion about when a proceeding ends becomes even more difficult, more challenging. And then I think if you throw into that soup the other bracketed language at the end of 4.1, which is or any other proceeding, then the question is, so that point, you're not even just talking about 2 IID proceedings. You may be talking about an enforcement action locally. You may be talking about a challenge to an award. You may be talking about an enforcement action in New York where you've been asked to act as an expert. So I think, and then when do those end? And who's going to enforce that? Because imagine if you've previously had the role of counsel or expert, and then you're looking at taking on an adjudicator role, then you obviously have to think about it in terms of things you are looking at when you're taking on that adjudicator role. And then you're under the auspices of some supervisory body who has adopted this code of conduct, and you must comply with it. And there's at least an enforcement mechanism, I think. But if it's the other way around, so you've previously acted as the arbitrator, and then you've gone out and taken a role as counsel or an expert, where is the enforcement mechanism? Who is in charge of, is this just, again, a self-enforcing thing? Fine. And what do we do with someone who breaks the rules? Is there still party autonomy there? Because I think the fact that you've built in the fact that that the parties could agree otherwise means that there's still some built-in freedom for a party to go to someone and say, I would like you to be my counsel in this matter. I realize you just acted as an arbitrator not long ago, but I would still really like you to be involved in this case. And there's built into this a mechanism where the parties can still agree otherwise. So there's got to be some latitude for that. So I think there's some practical issues there in terms of how we deal with a 3-year tail, as well as also dealing with other types of proceedings. What I do want to just quickly talk about, though, is where we think consensus is at. Where do we think people are thinking on this? And I think it's worth doing a quick survey of some of the more recent treaties and where they've landed on whether we should only deal with concurrent or whether we should be looking more broadly. If we look at the CPTPP, it is a prohibition. It is for the duration of the proceeding only, and it is under the CPTPP or any other international agreement. So it's not any other proceeding. It's not as broad, but it is for any other IID proceeding. If we look at the USMCA, prohibition, concurrent only, and only for disputes under the annexes to Chapter 14, the investment chapter, so narrower. Netherlands model BIT, prohibition, concurrent or the last 5 years. So it actually looks backwards. And it's under this agreement or any other investment agreement. The Slovak model BIT, prohibition, concurrent only, this agreement or any other international agreement. South African Development Committee model BIT, prohibition on concurrent or potential. So there you have another element about what if you're advising with respect to a dispute that's not yet been started. So I think what I draw from that is I think there is broader consensus. If we're looking at state practice, we begin to see a tendency to say concurrent, definitely not. We say not under this agreement. And I think there's a building up to also not under any other investment agreement. We don't see anything else that says any other proceeding yet. And we also don't yet see things that talk about a 3-year tail. So I think that may be one of the areas where there's still going to be some movement.
Thank you, Kate. Andrés, what would you like to add? I'll warn everybody just to protect. This is where it will get very frustrating.
I will start my chronograph now. Well, very briefly, 2 comments. First of all, this is one of the 2 matters that are left open for discussion in the current draft. It's bracketed. So it's obviously that And I want to remind everybody that this is a document for informal consultation that tried to reflect what was the discussion in the last working group, and it's the fourth version. So it's far from final, and in a sense, as I said, and I will come back to this point, try to strike a balance from the different views. But as I said, this is one of the issues that is open for discussion, and some states have already noted that the IID proceedings are long enough to cover to prevent any potential conflict. Going a bit more deeply, I think that for me the question is, and it's something that Kate said in one of her intervention, is if it's consistent or not with the rationale, right? With the rationale of why you are trying to prohibit double hunting. And it's not clear to me that it's consistent with the rationale, because even under the perception of a potential conflict, which is the reason for double hunting in some of the prohibitions, if the problem is having a concurrent role, which we all agree, the question why once the role ends, you still have to maintain the prohibition if the role ends. So you can, because the idea is that if you are in the both positions, you have a bias. You as an arbitrator may tend to look things in a way that, may favor your case, or, may create the problem legitimacy system. If we accept that counsel and arbitrators can be in non-concurrent form, the question why you have to put some time, 3 years, I think it's not completely consistent from the rationale, but it's part of the intent to trying to find a compromise somehow between a total ban and a more limited ban. So it's giving here and there a little bit to what were some of the concerns. But having said that, I think for me, one of the main problems of the 3 years that goes directly against one of the main concerns expressed by the states, and not just the states that are in favor of disclosure, also states that are in favor of a prohibition, limited or absolute, that this may have an impact in the diversity of the pool of arbitrators and the availability of arbitrators. And everybody understands that this will happen if you have a total ban. You may have a more limited, you have a limited ban. But if you put the 3 years, and the reason is, look, if you only can be an arbitrator, you have your first case, well, it would be difficult then to sustain yourself with one case. And so this says, it creates a problem of the people that will be available, and and how diverse will grow the pool of arbitrators. So the point is that if you put the 3 years, you are seriously limiting the ability of this concern, because now you only will not be a concurrent role. You will not be able to be counsel. This is the way it's drafted now. You will not be able to be counsel. Expert doesn't matter, but there are very little expert lawyers experts in investment arbitration nowadays. So it's something that is not relevant in my view. But as a counsel, you cannot be counsel for 3 years. So it's a serious limitation, and that would further affect then the concern about the lack of diversity and the availability and the party autonomy related to that of arbitrators that the double hatching ban may create.
Thank you.
I'll try to be brief. So I agree with that, Andrea. And I really was trying to think about why have that be prevailed? What is the point? What is the problem that solved? And I thought, well, maybe it's like somewhat more linked to the did you jury or as arbitrator develop a relationship with other arbitrators, arbitrators on which you can capitalize? So that do they view you as a fellow arbitrator and counsel, so that you're arguing in front of them, then perhaps you're more persistent than the otherwise would be ordinary.
That too, sorry, I'm reading the microphone, but that too, that would seem, and is Andreas's point, that particular instance would seem to be captured already by other prohibitions. You couldn't do that. So then it's a little bit unclear what that 3-year period is meant to accomplish. And I agree that it really would have potentially a preclusive effect. We know from work done by pluricourts that many, and by ICSID, that many arbitrators have one appointment and that's it. So if you hang out your shingle as an arbitrator, say, that's what I'm going to do, you get one case, it settles, you, let's say, make no money or almost no money on that case. Are you then banned for 3 years from practicing in the only area you know how to do anything in anymore? That seems not consistent, again, with broadening the pool. And it just, so I just wonder, I do wonder kind of what the impetus really was for that. So I'll stop there. I know we're running short on time.
So it doesn't seem to present the concern in concurrency that your judgment's going to be influenced by a different interest. That is your obligation to zealously represent the client when the thing is done, unless you were so devious as to anticipate generating work or you're going to try to, it's less clear.
Am I allowed to provoke discussion with a small contrary view?
I would prefer no, unless we have time at the end, and then you'll go back to it, okay? Because we are short. Andrés, we talked amongst ourselves, and some of us noticed that careful readers might have seen a bit of a drift away from disclosure. And so our question that you were going to lead the discussion on, is that accurate? Has there been a move away from disclosure? What's driving that, and what does party autonomy have to do with this?
Thank you very much, Donald, and I will be brief. I think that the issue of disclosure and why disclosure is not in the current version of Article 4, I don't think it's the drift away or a change in position. I think a little bit of history is necessary to understand that. There has been 3 versions, and in the group, basically in the States, you have 3 different groups. You have the state that think that an outright ban, a total ban is necessary, is the way. Other thing that has to be more limited. Another thing that disclosure is enough. And I think the reason why there is this different approach, because there is one group, in particular the group of the outright ban, that thinks that there is an inherent problem in lawyers acting as arbitrator acting as counsel at the same time, and creates a problem for the system and its legitimacy because it gives an appearance of bias. And that's a potential, maybe a conflict of interest, but also a potential bias. And that's enough to prohibit it, even if there is no conflict of interest as we understand under Article 3. And there are other states, the one I would say in the part of the disclosure, that think that the problem is a problem of independence and impartiality. And therefore, the way you address a problem of independence and impartiality is through disclosure. And then you let Article 3 to do its job, which is basically you have to determine that in the concrete situation, there is a problem of impartiality and independence. So you have these 2 different views, and the competing values behind that I think are shared by the working group is that part of the working group said, look, there is a problem here because if there is concurrency between lawyers and arbitrator, there is an appearance of bias that is damaging the system, affect the legitimacy of the system. Where others said that may be true, but if we have a total ban, we will limit the diversity. We will increase the lack of diversity, already recognized problem in the pool of arbitrators on the investment arbitration. And in addition, we will affect the party autonomy because the availability of arbitrators will be smaller. And if it's smaller, your ability to choose arbitrators will be limited. So there you have these competing values. And the working group has struggling with different views to try to see how is to best address these competing values. As I said, some states think it's disclosure because it's an issue of conflict of interest. And the other thing, the most relevant issue is the appearance of bias that affecting the legitimacy of the system, and therefore you have to prohibit it in the way that is prohibited in the CPTPP, etc., which is a complete ban. You cannot be, doesn't matter if the same provision or not. When you understand that, and you look at version 3 of November 2021, you see that version 3 had 3 options: complete ban, limited ban, disclosure. Then there was the discussion of the working group. The working group not necessarily moved from there. It's true that a number of countries that are in favor of disclosure said that they can live with a limited ban because they think that could be a compromise in the competing values. no, with a limited ban, but still they haven't abandoned their position. So what this proposal is trying to make is to strike a balance somehow, a compromise between among these three different positions. And this is why, and the understanding of the informal paper that is proposing is that disclosure is not there, because somehow option Article 4 now, the current version, represents a compromise because it's not total ban and it's not disclosure. We may argue that for those countries that favor disclosure, this is a middle ground or not. We may discuss that. They may say that a ban is still a ban and therefore creates a problem, especially 4.2, for example, even though those countries accepted that similarity of legal issues could lead to a problem. So you see, what's really happening is that it's not that has been a shift in the view. What happened is that this is trying to reach a consensus, to reach a way forward in the group. This is the way in which this has to be understood. And the question is if this will be perceived or will be understood by the country, the member state, as a good compromise, or the compromise need to move forward, how the competing values will be properly addressed or not by this. But I would say that disclosure is still at the table, but at some point it's obvious. Some people know I'm chairing working group too, so you have to reach consensus, you have to move forward, you have to at some point being able to find a common ground, and that's the way basically this type of work at the end it can make progress. I think so. I think this is what explains the version that we have in front of us, which, as I said, if you look at Article 4, the limitation is rather narrow for 1, and you have the issue that I already mentioned in 4.2. So, and then the question, obvious, I have to say 2 things very briefly to finalize. It's still debatable what is the role that disclosure will maintain, because as Lauren was saying, it's not clear that if you have a Article 4 as you have now, the other double hatting is understood not to be problematic. Because let me give you 2 examples. Someone may say, look, if it's the same provision of the treaty, but what if it's the same provision but in another treaty? We all know that the treaty has very similar provisions. The Chile FTA with the US was based on NAFTA, so it's like exactly the same language. And I mean, and we can go to the and many others that had repeated the language of fair and equitable treatment and other provisions. That would be understood. That can lead also to a provision under Article 3, because at the end, the rationale is the same. You are on the same provision if it's not the same treaty, or you understand that this is a formal provision and establish also the limits. That's a very important question, because otherwise your disclosure will play a very important role in, and actually there is a very broad disclosure obligation in Article 10. All the cases in which you have been involved, all of them. In ISDS, you will have to disclose all the cases. And therefore, that would be an interesting question that has to be addressed probably in the commentary. And the second example, other type of proceeding, commercial cases, for example. All of us has been involved on all of them. Some of us have been involved, not to exaggerate, in cases where you have an ICC or a commercial dispute, and in parallel, a dispute that is an ISDS. No? So it's not uncommon that you may have a dispute with a state entity or even the state that is commercial. That would be captured by the prohibition. The rationale for me is the same, but it's not here, so you would say it's Article 3. But since you're establishing a ban, it will be very relevant on how the disclosure operates. So I think that the disclosure will keep having a very important role, in particularly considering what are the boundaries that the commentary will establish for things that are similar or could be similarly considered with respect to the double hatting. And to finalize party autonomy, well, you have to find a compromise. And it's obviously that you have a problem of party autonomy if the pool of arbitrators is more limited. But on the other hand, you have to address also the concern of state that think that this is problematic. The question is if this is the right balance, and the states will accept that it's a reasonable limitation of their autonomy. The fact that you can agree with the other party that that you waive number 1, you cannot waive number 2. Number 2 is not waivable. It's only number 1 waivable, just to be clear. I don't think to what extent it's practical. What you will do it after you appoint your arbitrator, you will call your before appointing the arbitrator. You have to do it upfront. Say, let's agree that we can appoint parties that in concurrent cases. A state, I assure you, will say no. So I don't think I think I understand is trying to address the concern about party autonomy. The real practical value, I think, is rather limited.
Okay. No, I do think, I mean, I agree that this, is a compromise, and it seems to me desirable. The part of the third version where the option was that everything was placed on the back of disclosure seemed to abdicate responsibility for what the rules really were to some, nebulous future, common law, case law decision about what might or might not be permissible. And that seems especially salient given our discussion and given the working group discussions, which is that there's not necessarily complete agreement about what is acceptable and what isn't. We can agree on, let's say, 4.1, but on 4.2, maybe the scope of that is not clear. So, it might be that some arbitrators would say, oh, there might be a problem, I'm not going to do this. But I can imagine others who think either there just is no problem, or I'm going to gamble that there's no problem, or whatever you want to say. So, and that seems to me not what we want. I think we want, and I think of that both as, I don't know, a member of the community and as an arbitrator, that, I would like to act ethically. I would like to know what that means. I want to honor those obligations. And if what honoring those obligations means is I tell you everything I've ever done and then see what happens. That does not seem to be consistent with, ensuring ethical behavior. So I think this is I do think this is a welcome development. But I wonder if it's almost too much of a departure from disclosure, from not just from having links or clearer links between Article 4 and Article 10. What is it that disclosure is going to accomplish? If I have, and especially with respect to Article 4.2, which at the moment isn't subject to party autonomy, which I find a little bit interesting. And I know that in the commentary it said that this is something that should be considered by the delegates, but it seems to me a little bit peculiar that Article 4.1, which includes activities that we pretty well all agree should not happen, and maybe you could imagine, I don't know, limited instances in which parties might agree. And I was thinking about, informal consolidation, right? What if the state really wants, if everybody agrees to have the same arbitrators in the same cases, or in similar cases for efficiency? At least we used to see that in the old days, for example. But Article 4.2 doesn't seem to have that provision. And so I find that a little bit peculiar, especially given the breadth of the potential similar legal issue. So I gather that the working group is going to reconsider that. But it seems like it would be desirable to have some link to Article 10 and the disclosure, and what happens once that disclosure has been made. I mean, I appreciate, and there should be a continuing duty on the arbitrator, but if the arbitrator discloses that she has sat in a NAFTA Chapter 11 arbitration, and this is a US-Chile free trade agreement arbitration, does that mean, and the parties know that, and let's say Chile knows that, everybody knows that, does that mean that people have agreed to that, or is that just they're forbidden? And that seems to me not answered as clearly as might be desirable. So those are the and the other, I can think of more, I can think of more benign examples where a party might agree to, let's say, the finishing of a representation. Let's say you're an expert witness in a case that has been going on for 2.5 years. There's a possibility, not very likely, that you're going to be called to testify. And it has nothing to do with the case in question. It's an IID proceeding. It's about international investment law, but it is under a different agreement. It's about different issues. Would a party potentially agree to let you finish your obligation in that expert representation? And there are still a few. Or would you be obliged to withdraw from that expert representation? And I guess I can't imagine states that would say, yeah, you could go ahead and finish. maybe I'm wrong, but I'll stop there.
Warren, additional thoughts?
Very quickly, responding to one point that you just made, Andrea, and one point that Andres made. I agree strongly with your point, Andrea, that disclosure is not in Article 4 now, but disclosure is not dead by any means. That Article 10 is quite exhaustive in requiring disclosure, including of concurrent multiple roles. And I'm looking here at Article 10.2c that under this current draft, there is an obligation to disclose all IID and related proceedings over the last 5 years where you have been arbitrator or counsel. I read that to include concurrent cases. And I think this is the maybe sleeping giant provision in Article 10. There are a lot of important provisions in Article 10, but to the extent that the balance is not quite perfect in Article 4 in terms of per se bans, I do think it behooves the working group to consider, well, what can Article 10.2c do? Is it too broad? Is it not broad enough? Do we need the kinds of clarifications that Andres and I spoke about in Article 3, explaining the relationship between 3, 4, and 10, not just 3 and 4? I think it's a really, really critical point. And I don't know that I'll take up the invitation that Donald offered to disagree on disclosure. I do think, though, just to flag, and maybe there'll be comments, that in speaking to arbitrators about Article 10, there certainly is concern that it's going to create greater likelihood of challenges, of spurious challenges that will create concerns for arbitrators, also cost and duration concerns for disputes if you have this sort of open-ended disclosure obligations. Now, very quickly on Andres's a point about consensus. And I think you made the point as well, Andrea, that I think there's no question that the reason we see a movement away from disclosure in Article 4 proper is this very serious effort to divine a consensus in the working group. And I don't want to be provocative, but I think that it's a very challenging task, particularly because this code of conduct has never been vetted in person in the working group. That with all credit to the secretariats, there has been a 2.5-year long process that's been conducted entirely online, where there has been really impressive participation by states, but not nearly the participation that you see in person. And what I mean by that is you have fewer people from governments attending, and you also have fewer governments that are attending, participating. And I have read and scanned all of the written comments on the code. I've participated in all the meetings, and I would say that conservatively 20 to 40 states are the limited universe of states that have commented orally or in writing on the code, not to mention this particular issue. And so I do think that it is an unenviable task trying to ascertain a consensus when you've had relative silence from the majority of the working group. And I think we'll see what happens in September. Hopefully we'll have an in-person meeting in Vienna. And I think that the hope from my perspective would be that we see, is this the consensus or is it not? Is the consensus actually leaning more in the direction of disclosure or in a different direction altogether?
Great. Hey, quick comment from before.
Yeah, very a small comment, but not a minor issue. I'm not sure that the effect on diversity is necessarily likely to be as articulated by Andrés. I think that law firms, perhaps potentially bigger law firms particularly, but also many others, are already adopting policies that said, you know what, we don't act as arbitrators in investor-state arbitration matters. You're counsel, that's your main job, and it's just too difficult to try and take on the arbitrator work. It just creates either an appearance of, or a real prospect of, or actually an issue. And I think if law firms are doing that sort of self-regulation already, I actually think that the full ban is something that, it's not as unacceptable to the profession as I think some views take it. I think a lot of us have recognized that issue for a long, long time. I think that what we are seeing is a lot of practitioners going independent earlier in their careers than they would otherwise have done. Once they have an interest in acting as an arbitrator, if they've got a state who's interested in putting them on the ICSID list, or they're looking to get those kinds of appointments, you're actually seeing those people go independent from their law firms at a younger age, which I actually think increases the pool of people who are available.
Okay. So what I'd like to ask is that
to the remote.
Thank you so much for this. Just one question about the double hatting. Did the working group consider the idea of the mediator? Like whether the arbitrator can act in the prospective dispute as a mediator or not?
Someone appointed as an arbitrator can act as a mediator in that dispute.
Yes, so instead of the legal representative or the expert, a mediator.
Well, it was considered, but it was quickly dismissed because the mediator's role is so different from an arbitrator's role and a judge role. So it was considered.
The whole idea of an arbitrator moving over to mediation and then back to arbitration is considered differently in different. I'm going to quote on not only necessarily under different legal systems, but under different legal cultures. And some of us from, well, I'll leave it at that. Okay, for some who've grown up with the strictest division between that, when you're in a different legal culture and more acceptable, makes one worry about whether or not that may taint the arbitral tribunal. But in any event, who else? Please.
I just have a curiosity question. Did the committee look into annulment proceedings? I'm sort of curious what the measure is if you're an annulment committee looking at something. Is it the annulment provisions are the measures or the underlying treaty dispute, which in theory they're not investigating, and sort of how that could impact, an annulment committee member from future sitting as counsel? Sorry.
Martina, please. You get asked another question, we're going to give you a seat up here.
You guys get to hold on to the mic.
Yeah, ad hoc committee members are covered by the code to the same extent as the arbitrators. So that would go for them as well. So anyone, if there is a full ban on double hatting, for instance, anyone who is on the ICSID panel who is a double hatter would be excluded from appointment under the code, which is, of course, not something considered by the ICSID convention. So that is another consideration to be taken into account in the whole equation.
If I just,
What about the question, Martina, about whether it's the, Article 52 or whether it's the underlying issues?
Yeah, you are looking at potentially manifest excess power that could go to many things, including the underlying issues. So it's covered.
yeah, and actually the definition of arbitrator includes ad hoc committee, so probably it will be extended any type of provision that you will have an arbitration for the ad hoc committee.
Who's next?
The 3-year tail is an interesting point, and I was trying to think what is the sense behind it as you guys were, and it reminds me a little bit of provisions in U.S. ethics, counsel ethics rules that govern government lawyers and judges that have somewhat similar concepts. The idea there being to reduce the incentive for the government.
I would just add very quickly, it's a broader question about the code. How do you enforce compliance with the code? This is a great and sticky example, but I'll reference the discussion around a kind of a naming and shaming approach of maybe there'll be, and this is all I think nascent at this point, but there'll be some kind of a list of bad actors. God knows who manages this list and due process for the arbitrators who are put on this list. There are lots of very sticky questions, and again, I think this is a really sticky example of compliance, but I do think it's a much broader issue across the code.
I'll just add, I think there's an institutional problem, which is that the institutions got to empower the tribunals to make this kind of decision. Normally, tribunals do not have at least express authority to decide whether to admit a party representative. In fact, that rule is absent in the commercial space as well, except for in the LCIA.
Well, And of course, another interesting feature is we might suspect that an arbitral tribunal would I don't know, consider that challenge and consider the rules and consider the code. What would a court do if you were in one of these any other proceedings? If you were in, I don't know, the Southern District of New York, and the counsel / ex-arbitrator said, look, under the rules of practice of New York, I'm not doing anything wrong. Will the judge, care, just to put it bluntly? And I'm not sure what the answer to that is. He might be, our counsel ex-arbitrator might care and might be named and shamed, but I'm not sure that one could count on a US court to enforce those rather ephemeral, what I think the US court might regard as ephemeral obligations. My fear is.
Okay, any further questions? Don't worry, there were refreshments. We'll still do that.
I don't know if the response would be that quick, but thank you to all. First, a great panel. The question was regarding what Kate wanted to say in terms of, she mentioned I might introduce some, provoking argument. So I just wanted to know if what it was, and if it was already addressed when you mentioned the issue about, large firms self-regulation and the impact on the arbitrators pool and diversity. Thank you.
Yes, that was it.
Sorry,
Yes.
if I may say just, but Kay has a different view than the working group, because in the working group, this is precisely one of the issues that have been repeatedly said, and I would say to a certain extent accepted, to have a more balanced approach. Yeah, the impact in the pool of the impact that this pool may have in the pool of arbitrators.